Looks like there's going to be a double date at the Durham County Courthouse on December 9th. First, Tim has a status conference in his lawsuit against Akira. If you're confused, have any questions, or this is the first you're hearing about said lawsuit, go check out the video right before this one. I walk through that entire case. And on the same day, Brenay is scheduled to appear for a disposition hearing regarding her cyberstalking case. In this video, we're going to walk through what a cyberstalking charge in North Carolina means, what the disposition hearing covers, and what a judge will realistically do if she is convicted. But first, my disclaimer, it's important that you read it. Please press pause. For anyone in my comments saying that I am giving Brenay ideas or advice, I am going to repeat this one last time. If you take the time to listen to my content all the way through, you will notice that in almost every breakdown, I'm showing you why certain motions, arguments, or appeals are unlikely to succeed by showing you the statute and case precedent that closes that door. I never make claims with certainty because these cases are still unfolding, and again, I'm not an attorney. I mention the option because it exists in the law, and I'm here to share what I've researched, not pick sides. That is not legal advice, that is education. Nobody should be taking legal advice from TikTok, and least of all from me. So if somebody chooses to do so, not only is it unwise, it is 100% not my problem. Good? Great. Now let's get into these documents. First, what is she charged with? According to the warrant for arrest out of Durham County, the state has charged Brenay with 1 count of misdemeanor cyberstalking under NC General Statute 14-196.3, which is a Class 2 misdemeanor. We will look at that statute shortly. On the continuation sheet of that same warrant, the state gets more specific. It says that Brenay posted messages using Snapchat, Facebook, and Instagram, and that these communications were used for the purpose of causing mental and emotional stress to the victim. So the charge itself, the platforms involved, and the alleged emotional impact are all documented directly in the warrant. Then we have the issuance of charges document, which includes a statement made by Akira and the officer's narrative. Akira's portion is handwritten, and I've chosen not to show that here. I don't believe she wrote it for internet consumption, and out of respect for her privacy, I'm leaving that out. I will share that her statement indicates preserved electronic evidence exists, including screenshots and a flash drive provided to law enforcement, and the officer's narrative confirms that. The officer also notes that there is an existing restraining order requiring Brenay to cease harassment of the plaintiff, and that Akira's attorney has screenshots of posts made across Snapchat, Facebook, and TikTok. So, putting these filings together, the picture being presented to the court is not a one-off comment. It is an alleged pattern of online harassment across multiple platforms in the context of an existing court order already telling her to stop. Now let's look at the statute. This is NC General Statute 14-196.3 regarding cyberstalking. This document is 3 pages long, so I'll be flipping through. Feel free to pause. Under this statute, cyberstalking includes using electronic communication to threaten someone, sending repeated electronic communications to harass, annoy, abuse, torment, or embarrass, or sending false statements electronically with the intent to harass or intimidate. And electronic communication includes social media posts, comments, stories, DMs, text, iMessage, email, WhatsApp, Messenger, Discord, group chats, forums, and even gaming chats. So the platforms listed in the filings fit squarely within the statute. So what is a disposition hearing? A disposition hearing is not a trial. There are no witnesses and no jury. In North Carolina, disposition simply means what is happening with this case next. Now, one of 3 things can happen. She can either enter a plea agreement, the case can be continued, or the court sets the case for trial. It's not the finish line, it's the checkpoint, unless a plea is entered. And if that's the case, I'm going to show you the sentencing grid. This is NC General Statute 15A-1340.23, the misdemeanor sentencing grid. And it's unclear to me whether Brenay has any prior convictions, so for the purpose of this explanation, I'm going to assume she does not have any priors. Under this statute, a Class 2 misdemeanor for someone with no prior convictions falls into Class 2 Level 1, which says 1 to 30 days, C, or community punishment only. I highlighted the definitions above. This means no initial jail time. The judge cannot give her straight active time at sentencing because you don't see that A on the grid. And just so we're clear, that 1 to 30 days you see in the grid does not mean she'd only be on probation for 1 to 30 days. That number is simply the amount of jail time the judge puts on paper and then suspends. Probation is separate and usually lasts months, often 6 to 12 months. The 1 to 30 days is the backup time she would serve only if she violates probation. Were there an I in this row like you see in some of the others, that would mean there is intermediate punishment. In this case, there isn't. Intermediate punishment is the middle ground between community punishment and active jail. It can include things like shore jail splits, house arrest with electric monitoring, or intensive probation. None of that applies here. What does apply is community punishment only. This includes probation, fines, community service, counseling, and behavior-based restrictions, including limits on application use. Now, let's talk about what conditions a judge can impose. I'm showing you NC General Statute 15A-1343 for conditions of probation. Under this statute, the judge can impose conditions reasonably related to protecting the victim and preventing future harm, which can include no contact with Akira, no contact with her immediate family, no posting about Akira or the children, providing all social media usernames, having no burner or fake accounts, and targeted bans on specific platforms that were used in the alleged offense. What a judge cannot do, because of Packingham versus North Carolina, is ban her from the entire internet or all social media with no tailoring. A targeted ban is allowed, a blanket ban is not. And although the judge cannot ban her from the entire internet, the judge is fully within their legal right to ban her from any specific application the state alleges she used to cyberstalk and harass, including Snapchat, Facebook, Instagram, and TikTok. Those targeted restrictions are lawful because they directly match the conduct described in the charging documents. I can already anticipate some questions, so I'm going to get ahead of them. The first being, does being an influencer protect her from app bans? No. Probation conditions are about protecting the victim, not protecting the defendant's brand. If the harassment happened on TikTok, Snapchat, Facebook, or Instagram, the judge can restrict those apps, even if they're part of her income. That's well within the court's authority as long as the restriction is narrowly tied to the offense. The second one, so if she enters a plea or is convicted, what actually happens? If she takes a plea or is found guilty, here are some of the realistic outcomes for a Class 2 misdemeanor with no prior convictions. The first, probation. This is the most likely. The judge would impose a suspended 1 to 30-day jail sentence on paper and then place her on months of probation with conditions like no contact, no posting about the victim, no burner accounts, and targeted app restrictions. The second one would be fines and court costs. Every conviction comes with financial penalties. The third would be community service or counseling. Judges often add these when the conduct involves harassment, intimidation, or repeated conflict. And last, jail, but only if she violates probation later. She does not go to jail at sentencing under this grid. But if she violates the terms the judge sets, including any app bans, the suspended jail time can be activated. There's no scenario under this grid where she walks into court and gets straight active jail at sentencing. Another question I anticipate is, does this mean she can't be around Akira's kids? If convicted, a judge can restrict contact, including with the children, if the court views that contact as part of the harassment pattern. But criminal court does not change custody. That belongs to family court. And now the million-dollar question. Could Brenay calling herself a mom online be considered harassment? Well, one isolated mom reference is not cyberstalking. But under the restraining order that's in place, she must cease harassment. Given prior testimony that the children experienced confusion and emotional distress when told to call Brenay mom, repeated online use of that title could be interpreted as a continuation of the same behavior the order was meant to stop. If done knowingly and repeatedly, a judge could view it as harassment. I know this is going to raise even more questions, so I'll be watching the comments and doing my best to research whatever comes up next. Don't forget to like, comment, share, follow for more updates, and I'll catch you in the next one.